city council is that you have to have process here in order to get things done and be able to bring stakeholders together. And that is exactly what this is doing. So I'm not surprised if some folks are skeptical, but I remind you that there's been skepticism in the past around this, and look at the results that we've been able to produce in our short time as new council members when it comes to these kind of issues. So I am supportive of this staff direction, and I appreciate my colleagues bringing it forward. And I also just wanted to speak specifically to staff on this as well. I do expect that this staff direction will pass. I understand that that is the city council prioritizing this work. I understand that that may mean that there's a lot of stress and a lot of effort involved in that. And so I understand that other priorities or other work you are doing, that the timelines may be affected by that. And so I would urge you to remind me and my colleagues of that, that when you're working on this, that we understand that we've made this a priority, and this is something that is ultimately going to bump some of our other work or postpone it or delay it. And I appreciate staff for all of their future work on this and look forward to working with you.
Councilmember Frye.
Thank you, Madam Chair. About 2 years ago, I expressed support for an increased minimum wage and explicitly said that we could do so at the city level. I am also very supportive of the content of Councilmember Cano's amendment, but I do think that we need to go through the process to do this right, and that's why I'm sticking with the underlying amendment. There's a clear majority that believes that we need to go in this direction, I think. And I feel very confident that we will be able to enact a minimum wage policy at the city level next year.
Councilmember Cano.
Thank you, Madam Chair. Procedurally, somebody could make a motion to include some of the portions of the amendment that I put forward if folks want to reconsider some of their positions here. I think it's important to acknowledge that the nonprofit groups, the advocates, and the coalition that has come together to work on these issues really wants more time to be able to work on this staff direction with our policymakers, and I think that partnership is important, and I think we should consider honoring that. I don't think it means that people don't want to take this initiative forward, that people wouldn't support the staff direction later. I think that if we are able to put this on hold and work out some of the details to make it stronger for both the community and our council colleagues, that would make sense, including, some of the comments that Councilmember Linnea Palmisano made today. I think it does make sense to try to figure out how we can make this a little bit stronger, and acknowledge also Councilmember Cam Gordon's notes about the timing of this and when this could be introduced, so that it's aligned better with the current work that the council is doing to look at raising the wage, both through our study and through the mechanisms that the staff is putting together to release that study into the public. So I just wanted to make a note that that's still on the table, that somebody could choose to change this language a little bit and try to get it amended, including any of the leading authors of the staff direction, to send a stronger message to the community that we're serious about raising the wage, specifically around, some of the businesses that are above 500 employees, which we know is already something the charter language and the community agrees with, and is in line with the national trends we're seeing, and is also something that I think most policymakers understand to be very feasible and realistic. I do appreciate that the staff direction, as it's written, doesn't include anything about, negatively impacting some of the relationships we have, because there is some community engagement language in there, and that's excellent. I do want to acknowledge that the small business community is very present in my mind, and of course the small business owners on East Lake Street, who I work with regularly every day, many of them Latino, many of them Somali, much like Councilmember Warsama's ward. And so that's why the specific language that I suggested on the amendment was focusing on the businesses that were above 500 employees. So I want to make sure that that doesn't get lost in the conversation. So with that, I would be happy to reconsider some language that is changed in the original staff direction, but because of issues of timing and lack of clarity, I think that I'm just not going to be able to vote on the original staff direction as it was presented at 10 a.m. this morning.
So Councilmember Gordon.
Yeah, I'd like to
Councilmember
move.
Gordon is asked to speak.
Thank you, Madam
Councilmember
Vice
Gordon.
President. I move to table. I think we can take this up at the next committee of the whole. And we'll talk about it. Obviously,
That
if I
is essentially
could.
a motion to postpone. Did you want to speak? Or?
Yeah, just briefly, if I could. I think obviously Councilmember Fry has indicated some interest in adding maybe 15 more specifically. There's lots of details to be worked out. I didn't see the staff direction until after the meeting had started. So I think it would be nice, and we have a good shot at getting I think a unanimous vote at the next committee of the whole. Obviously, we've presented this now today. Everybody understands we take it seriously, and we're going to work together on it, even if we table it just till the next committee meeting, and then we can come back with a really clear staff direction, hopefully with unanimous support from all council members.
Okay. So,
Yes, you want to vote yes.
Councilmember Gordon has made a motion to postpone, and Council President Johnson is in the priority motion line, so I'm going to call on her.
Madam Chair, I would move to call the question.
So that is calling the question on the motion to postpone.
I'm sorry. No, I'm not underlining.
So how does that work then? I think we have to vote on the motion to postpone first, and then, okay. So we have a motion from Councilmember Gordon. All in approval, please say aye. Aye. All opposed? No. Nay. Believe the roll call. All right.
Postpone, right?
Okay.
Postpone, right?
This is on Councilmember Gordon's motion to postpone. The clerk will call the roll.
Councilmember Gordon.
Aye.
Kano.
Aye.
Reich. Bender.
No.
Andrew Johnson.
No.
Yang.
Aye.
Quincy.
Nay.
Warsami.
Aye.
Goodman is absent. Fry.
Aye.
Palmisano.
Aye.
President Johnson.
No.
Chair Glidden.
No.
There are 6 ayes and 6 nays.
All right. So we are in recess. So we are happy to continue our business if we're able to conduct the meeting. I'm asking my colleagues to take their seats. And to everyone, we are back in session after a recess. we have to return to the order of business that was in front of us. And I'm going to double check myself with the city clerk. My understanding was that kind of the last piece before us was Council President Johnson's calling of the question on the underlying motion by Fry, Warsame, and Bender. And is that accurate? I just
Madam Vice
want to
President,
double
yes.
check.
Prior to the recess, the motion to postpone the staff directive made by Councilmember Gordon had resulted in a tie vote, as you know, which means that fails and falls to the floor. Before that vote was taken, however, President Johnson had offered a motion to call the question, which requires us to take up the immediate question that's pending, which is the original staff directive authored by Council members Fry, Warsame, and Bender. That becomes the immediate action before the body now.
Okay. So Council President Johnson has called the question on the Fry, Warsame, Bender staff direction. So all in favor of the staff direction, please say aye. Aye. Oh, I apologize. It's okay. Yep, thank you. All in favor of calling the question? Aye. All opposed? I believe the ayes have it. So then on the underlying question of the Fry, Warsame, Bender staff direction, all in approval, please say aye. Aye. All opposed? Okay. Yes, that's a courtesy. Clerk will call the roll on the staff direction vote.
Councilmember Gordon.
Aye.
Kano.
No.
Reich.
Aye.
Bender.
Aye.
Andrew Johnson.
Aye.
Yang.
No.
Quincy.
Aye.
Warsame.
Aye.
Fry.
Aye.
Palmisano.
No.
President Johnson.
Aye.
Chair Glidden.
Aye.
There are 9 ayes and 3 nays.
Thank you. So I believe with that, we have concluded with the business that relates to the. We now have another important item before us, which is the.
He is disturbing a government meeting. He needs to be removed. You have language about
Their leader.
All right, good. Okay, good. Good.
So thank you very much. We have another important item before us, and I appreciate those from that petition campaign waiting very patiently. We're going to have just and hopefully this might be a little briefer, Mr. Carl, overview of what's before us with this item, and then we have an opportunity for the petition campaign to present their views, and I believe they also have a PowerPoint, and we want to make sure we're helping them with that.
Madam Vice President, the second petition pending before this body today is submitted by the Committee for Professional Policing through its chair, Dave Bicking, who is present today. The petition seeks to amend the city charter to require that Minneapolis police officers carry professional liability insurance throughout their terms of service, which, if approved by voters, would become effective 1 year after its passage. The petition was submitted to the Charter Commission on June 13th and transferred to the city the next business day by filing with the Office of City Clerk. The first review of that petition found it to be insufficient in meeting minimum statutory requirements. An amended petition was subsequently filed on July 5, which was found to be sufficient and in compliance with statutory requirements on July 11. At its regular meeting on July 22, the City Council referred the subject matter of this petition to this committee for its review, evaluation, and formal recommendation for action by the full City Council, consistent with the procedural rules of the City Council and subject to the provisions of Minnesota Statutes Section 410.12, Subdivision 4. As I have already indicated in the prior petition, the City Council has a ministerial duty that's provided by state law for the handling of citizen petitions to amend home rule charters. Specifically, petitions that are deemed valid must be referred to the governing body of the municipality, that is the City Council, so that it may fix the form of the ballot question. That's the statutory language. What it means is that it is the duty of the council to determine the language used in submitting the ballot question to the electorate. The statute requires the wording of the ballot to be sufficiently to identify it clearly and distinguishing it from every other question on the ballot. We've discussed the form that is required by statute. As directed by City Council, the City Attorney did draft proposed ballot language, copies of which were posted to the city's website on Thursday, July 28. Copies of that ballot question are included in your briefing materials. They also were made available to the public for this meeting. The draft ballot language prepared by your city attorney complies with the statutory formatting requirement. As with the first petition, the city attorney requested that I provide her draft ballot language to the petitioner, which I did via email to the committee chair on Thursday, July 28. As of this morning, I have not received any response from the committee about the draft ballot language prepared by the city attorney.
And I will just let you know that, I'll make sure, they did communicate with me, and I have received some comment, and I also shared that with the city attorney. So I just want to make sure we know that we did get that, and we appreciate the feedback.
For the sake of the viewing audience and those in the chamber who may not have a printed copy of the revised ballot language that's been proposed, I'd like to read that text. The question is, shall the Minneapolis City Charter be amended effective November 8, 2017 to require all Minneapolis police officers to purchase and maintain continuous coverage under individual professional liability insurance policies, such policies to be the primary insurance for the officers and to include coverage for willful or malicious acts and acts outside the scope of the officer's employment by the city, with the city having the option to reimburse officers for the base rate of coverage, but with police officers being responsible for any additional costs due to personal or claims history, and prohibiting the city from indemnifying a police officer against liability in any amount greater than required by state statute unless the officer's insurance is exhausted. Pursuant to Minnesota statutes, the clerk must submit the ballot questions to the auditor no less than 74 days before the election. Again, as a reminder, that date is Friday, August 26th, about 3 weeks away. I've also mentioned that the full text of the amendments must be published in both the Star Tribune and the Finance and Commerce paper, which is our official newspaper of the city, for 2 successive weeks prior to being on the ballot. To be enacted, the ballot question requires that at least 51% of affirmative votes of all those voting on the question are tallied. If enacted, then the amendment would become legally effective and codified 30 days after the election unless a later effective date is provided. In that case, the amendment would be enacted by the voters. The requirement for police officers to carry professional liability insurance would become effective 1 year after the date of the election, which is November 8, 2017. Completes my review of the statutory procedures governing consideration of this proposed amendment. Again, it's the duty of the council to determine the form of the question by approving language to submit to the electorate. I've concluded my prepared remarks and am happy to stand for questions if the committee has any.
Thank you. I just wanted to clarify one thing. I did communicate with this campaign, just as I did with the other campaign, to make sure that if they had feedback on the ballot question, they were submitting it. And it's my fault. I should have known that the city junk folder or spam filter sometimes is more aggressive than it should be. So I should have checked that. But we did communicate verbally, and for folks to know, and this is before the campaign takes its time to address us, they had identified that there is a word used, which is purchase the insurance. They had requested the word maintain be used instead of the word purchase. I had communicated to our city attorney, Susan Siegel, that I knew that the campaign would like a different word than the word purchase, and that they had referred to their original language presented when they were gathering signatures, which was the word maintain. The city attorney has proposed the word obtain instead of purchase. And so I think that's what I will move today, is replacing the word purchase with obtain, but knowing we probably are going to want to have more conversation with the campaign about this word obtain versus maintain. So I just want to say I'm open to that, but I think we might need to meet together after this meeting, if that's all right. So I think with that, I'm not seeing any questions. If the clerk could kind of clear out the question columns, that would be great from the council members. Oh, I'm sorry, Councilmember Cano.
I'm on using the electronic management system here. I do have a quick question. Could the city attorney please speak to that recommendation to change from purchase to obtain? And did you say also maintain will be substituted with obtain?
I apologize. I just put something in my mouth. The campaign so the original language proposed by the city attorney used the word purchase in the title, and then it appears again in the actual language of what would appear on the ballot. The campaign identified that as the word they did not agree with, and asked the word purchase, and asked for the word maintain to be used. So it would read, proposal to amend the Minneapolis City Charter to require police officers to maintain liability insurance. The city attorney has proposed a little different word, which is the word obtain. So it would, so for example, the title would read, proposal to amend the Minneapolis City Charter to require police officers to obtain liability insurance. I will just say there hasn't been conversation between the city attorney and the petitioners directly on this. So I just want to acknowledge that.
So my question was, could the city attorney please explain why she recommends obtain versus maintain? And I understand purchased is not desired.
Madam Chair and Councilmember Cano, I think it's fine to take out the word purchase, but I think you need some word because the proposed amendment says that they have to have proof of professional liability insurance coverage, which means they have to get it. So actually what I'm recommending is the police officers to obtain and maintain continuous coverage, because both of those concepts are in the proposal. They both have to have it. And then I know an important part of their proposal is the requirement that officers must maintain continuous coverage throughout their employment, creating a new condition of employment, as you know, if you will, that if they don't have it, presumably they can't be employed, or if they lose it, that they will lose their employment.
Okay, so I just want to, again, acknowledge that the petitioners haven't had an opportunity to have more conversation with the city attorney and the clerk about the difference between the obtain and maintain and whether we could have both words or whatever. And the purpose of their time, the 15 minutes, was more about responding to the legal argument about whether this is a proper subject for the ballot. If they would like to make some comments about that, I want to just offer you the flexibility. You know, we want you to have the time that you need to explain. We can also, you know, there will be time between now and Friday as well to have additional conversation. I just want to give you my commitment to having some further conversation. So if you would like to, and do we need any assistance for the PowerPoint? No. Okay.
I'm good.
I wasn't sure.
Chair Glidden, Council President Johnson, and council members, my name is Michelle Gross, and I am a board member with the Committee for Professional Policing. And thank you so much for allowing us to present information on our police insurance amendment in preparation for your vote on placing our amendment on the ballot. And we're happy to answer any questions that you have at the end. Before we talk about the amendment, I want to talk about the current state. As it is now, the city is self-insured for police incidents. When a victim of police brutality or misconduct sues the city decides case by case whether to indemnify, that means cover, the officer. While the city is not required to indemnify intentional acts, they almost always do, though they once in a while refuse. A recent example is the Blaine Lehner case, in which Officer Lehner kicked a handcuffed Luis Garcia in the face. The city refused to indemnify him. While that's good for the taxpayers, it could have been harmful to Mr. Garcia, as it would have been much harder for him to gain any measure of justice than to be compensated for his injuries through his lawsuit. However, even though the city wasn't going to indemnify Lehner, the city council voted to pay out $360,000 of taxpayer money to Mr. Garcia. Because the city is self-insured, funds for lawsuit settlements and judgments come from the city's self-insurance fund, which is part of the general fund. In other words, taxpayer dollars. However, even when an officer engages in conduct that results in a large payout, there have historically been no consequences for that officer because the officer is almost never disciplined. Therefore, there's no incentive for that officer to change the conduct that led to that lawsuit, and the only people who have consequences are the taxpayers. The police insurance amendment will require police officers to carry professional liability insurance. The city could, and we believe they should, cover the base rate of this insurance, but any premium increases due to police misconduct settlements and judgments would be the responsibility of the officer who caused the increase. There are a number of benefits to this approach. An officer who engages in misconduct that results in a premium increase will have a personal consequence for that conduct. This incentivizes that officer not to engage in this behavior in the future, applying a risk management strategy to policing that is not currently present. It also removes the element of politics in terms of who is disciplined and who isn't. Officers who don't learn that lesson and who continue to engage in misconduct will find that their rates increase, possibly to the point of being unaffordable, and in some cases, some officers may become uninsurable and thus no longer able to be employed by the Minneapolis Police Department. As the worst offenders leave, good officers will have a much better working environment. And this is not insignificant because surveys have, staff surveys, engagement surveys in the city show that the police department has the lowest rates of staff engagement. So this is not insignificant. Taxpayers will experience a significant financial relief. Police leadership will have a powerful new tool for managing their staff. And finally, decreases in police misconduct will increase the safety of the community and improve police community relations. For these reasons, we feel the police insurance amendment is a win for all. Taxpayers get relief, officers get guaranteed coverage, a benefit they don't now enjoy, and better policing is incentivized and the community is safer. Many occupations use professional liability insurance to drive out dangerous practitioners. FBI, CIA, and other federal agents carry professional liability insurance, and their agencies reimburse 50% of the cost. Other professionals such as doctors, nurses, lawyers, all of these folks, even plumbers and beauticians, all carry professional liability insurance. It's not a new concept. Our amendment is only novel because it applies these same risk management principles to policing. Police officers themselves are interested in having this coverage. In a March 17th article in Reuters, the Fraternal Order of Police, which is the largest police union in the country, reported that sales of their professional liability insurance have increased 15% in the last year. And this is with officers purchasing the insurance on their own and paying for it themselves. Is the police insurance amendment legal? We say yes. We took a year to carefully craft our language in consultation with attorneys, labor experts, insurance professionals, retired police officers, and many community stakeholders to ensure that our police insurance amendment is not only legal, but that it would be effective and that it would not present additional barriers for people seeking justice after being harmed by police. The main state law that covers the issue of indemnification is Statute 466.07, as does the union contract, of course, speak to that issue. Under these statutes and provisions, the city is required to cover payouts resulting from lawsuits against police officers in cases where the police officer was acting within their role and duty. However, willful and malicious acts outside the scope of the officer's employment, those kinds of things are specifically excluded. In these situations, police officers would be liable, and the city is under no obligation to defend the officers or pay damages resulting from legal actions, and as we mentioned before, sometimes the city has chosen not to. By definition, misconduct falls outside the scope of employment. There is no moral, legal, or union contractual obligation that the city continue to pay out millions of dollars a year in bailouts for officers who engage in this conduct, and it may very well be misappropriation of tax dollars for the city to continue to do so. Through our research, we have found that policies available to federal agents and other policing agents that choose to purchase the insurance include coverage for intentional acts. Once adopted, our police insurance amendment will ensure that police officers are covered for acts of misconduct. Officers will have better coverage than they have now, and community members who have been harmed by misconduct will benefit from officers having guaranteed coverage. I want to say a word about the police labor contract. Our police insurance amendment goes into effect a year after passage, as you've already heard, allowing time for the city and the Federation to negotiate the contract to determine who will pay the base rate for the insurance. And I want to say one other thing as well. In Ms. Siegel's opinion, she stated falsely that a note in our letter from our lawyer said that, and let me see if I can get her footnote correctly here. She basically claimed that we said that the union contract takes precedence over law. There was nothing in our letter that ever implied any such thing, and we do not believe that that's correct. I've made Ms. Siegel aware of that error. She has to date refused to address it, but nonetheless, we do not believe that the union contract trumps the law. In fact, it's the other way around. Let's talk about how this amendment might work in practice. There's a long history about how professional liability works in medical and other fields that we can draw from. In her opinion, Ms. Siegel states that there are a number of situations in which officers are sued when they have engaged in no misconduct at all, and we don't doubt that. We know that that's true. She also points out that in the situation of traffic accidents, there may be negligence, but not malfeasance, willful neglect, or bad faith. True again. In these instances, the city is required to defend and indemnify the officers and will do so as they currently do now. In instances of misconduct, the city has absolutely no obligation to defend and indemnify the officer, and as we have discussed, the city has sometimes chosen not to. In those cases, the insurance company would likely hire an attorney to defend the officer, and any payout would come from that insurance company. It's just that simple, folks. It's very easy to understand. Now let's talk about the financial aspects of this. Currently, judgments and settlements for police misconduct lawsuits cost the city about $2.5 million a year. Some years more, some years less, but that's running the average. And that doesn't include the hidden costs of legal fees for defending the city, paying officers and other city employees to be available to testify in court, depositions, etc. All the things that go into a lawsuit. This means we are spending about $3,000 per officer per year in judgments and settlements alone. And I'm talking about every officer here, including the ones that never cost the city 1 cent. These costs come from the city's self-insurance fund. In other words, we are literally budgeting for police misconduct. Because this kind of insurance has not been available in Minneapolis before, we don't know with certainty what the cost will be for it. However, our research indicates that the base rate for these policies will likely be in the range of $300 to $400, probably on the higher end of toward $400 per year. And that's because we know this from what officers purchase on their own, as well as the federal agents' insurance policies. If the city decides to pay for this base rate, and again, we hope that you do, this will still reflect a very significant savings over the current self-insurance scheme. Even if the initial costs would be higher, and we don't believe they will be, over time these costs will decrease as risk management strategies are applied that reduce the rate and number of incidents, and as police officers self-select to leave the department or become uninsurable and enforced out. We do expect that just as the base rate for professional liability insurance differs for various physician specialties, some police assignments will carry higher or lower base rates. Again, we would encourage the city to negotiate with the police union to cover the various base rates for this coverage as a new benefit for the officers. Minnesota statute, let's look at what I'm going to talk about now is the city council's obligation. Minnesota statute chapter 410 indicates that the city council has a ministerial duty to place our proposed amendment on the ballot since our petition has been certified as having sufficient signatures. There are a few exceptions that have been carved out through various lawsuits. These are if the amendment is in conflict with state or federal law or public policy, which really means the collective intent of state law, or if it or is not a proper subject for the charter. In these exceptions, the council may decline, but doesn't have to, but may decline to place an amendment on the ballot, but may also choose to place it on the ballot and allow the process to play out in the voting booth and in the courts later. We already know that the amendment is a proper subject for the charter, as it is just a continuation of Minneapolis Charter paragraph 7.3A2, which outlines the requirements for police officers in Minneapolis. So we already know it's a proper charter subject. Our amendment clearly does not violate public policy. In fact, it represents an improvement over the current situation. Finally, our amendment is not in conflict with state or federal statutes, as I've already outlined. Your other obligation is to submit ballot language, and we've provided you with our, apparently, however, through an email snafu, you didn't see our suggested language. We do prefer the term maintain, and the reason we prefer it is because it implies that the person will carry it throughout the course of their employment. And so we do prefer that term maintain. We think it's a more proper term. But basically, that's your other obligation, is to select the language and put this thing on the ballot. This has been a long road. Educating the public and collecting over 15,000 signatures to get this on the ballot was no easy feat. The road has been made even longer because the city has violated law and practice in putting us through delay after delay, illegal delay, in processing our amendment. We urge you to end these delays by voting to place this police insurance amendment on the ballot. You will not be in violation of Minnesota Statute 410 by placing it on the ballot, but should you choose to subvert the will of a significant portion of the population by voting no, we are prepared to go to court to seek an emergency action to get this measure on the ballot. Not only are we prepared to prove the legality of the police insurance amendment, but we will also bring in the many violations of law and practice the city has committed in its lengthy delay of processing our amendment. The city can avoid all this by voting yes to place the police insurance on the ballot. It is time to let the voters decide. Thank you.
Thank you, Ms. Gross. Anything else? Not seeing any. I guess I could ask. Sure.
Apologies.
And I'm going to ask the clerk if you could clear those speaker things from the, okay. It's just the speaker queues. We have the old speaker queues up.
And Mr. Bicking is also available to
Oh,
answer questions
maybe
as
something's
well.
on. So if folks can just let me know.
Mine isn't.
I apologize. We have the speaker management system and I'm somehow stuck in the
It's
last
It's fine. It's fine.
thing. Okay. Any questions from council members? Councilmember Kano.
Thank you. Thank you, Madam Chair. I would like to know from the committee sort of the impact that you think this would have on our police force in general. I know that I've heard some people worry that this is going to impact everybody negatively, or that it's going to lump everyone into one category and sort of, punish all the officers. So I'm just wondering if you could talk a little bit more about the differentiated approach and how you think this would really zero in on specific problems that we have, repeat problems within our workforce.
Thank you very much for that question, council members. This is not a punishment of the police. The great majority of police officers never have a lawsuit against them in their career. The great majority of police officers will pay the base rate for this insurance and have guaranteed coverage, which gives them the assurance that they are covered in any case, not just in those cases which are required by 466.07. So for the good officers, it is a benefit that they do not have now. For those officers who have a problem controlling themselves, following policy, following the law, they will be affected by this, definitely, in the sense that they will now have the disincentive of their insurance rates going up if there's a sign of significant risk. That sign may be previous lawsuits. What we have found is that in nearly every case where there is a very significant lawsuit against the city, that officer has a history which has already shown a high risk. And most of the settlements, most of the things that would cause the insurance rates to go up are the cases that, that will have identified those officers. Our police union president has said, well, it's like basketball. If you don't have enough fouls, you aren't playing hard enough. These are not fouls, and that indicates a cavalier attitude that is unfortunately too prevalent among some of the officers. And it's an attitude which says, yes, we can break the rules. And it's an attitude which leads to the kind of very vicious behavior that we sometimes see. That this is not a game. The rules in policing are laws, and the police officers must follow those also. So we need to change a culture which says it's okay to violate people's rights. And when officers see a consequence for that, which they do not right now, and one of the reasons they don't see that consequence is because when the city takes on the defense of all officers, regardless of whether they're required to or not, it means the city has an incentive to say, oh, that's a very good officer. He has a very good history. And so we find that the officers who come in front of your council, and you have these private meetings every couple of weeks, those officers that come in front of you are being defended by the city. They are getting no consequences. When there are consequences, people behave better. And when there is the possibility that they will lose the ability to work for the city, that will be, in some cases, a very positive development. Thank you.
Yeah. And I'd like to add, if I could, please. There, again, as Dave points out, it's a handful of officers that are truly problematic, but there are no consequences for those officers. The Office of Police Conduct Review, for example, at the end of the first quarter of 2016, had in those 3.5 years taken in 1,323 cases from members of the community. One case out of all of those cases in 3.5 years has been sustained and disciplined. One. This is not a way to address police misconduct. In fact, it sends a very powerful message that you can pretty much get away with anything you want to get away with. We have one officer on the force, Tyrone Barzi, who has had 7 lawsuits in a period of about 2 years. And his lawsuits have cost the city $380,000. Yet he remains on our payroll and has no consequences for that conduct. Again, not a way to address a very serious problem. And it's not just about tax dollars. It is about tax dollars, but it's not just about tax dollars. It's about real people who get really hurt. There are people in our community that are suffering, that have long-term injuries, that some people are killed. It is about that. And so whether we talk about dollars and cents and all of this other stuff, and I do believe our amendment is cheaper, is less expensive for the city. But even if it wouldn't be, there is a cost for people's lives and bodies. And that's a significant expense that we have to not ignore. So thank you.
All right, we had one other question from Councilmember Yang.
Thank you, Madam Vice President. Ms. Gross and Mr. Bacon, you both are guessing as to how much it would cost for police liability insurance. Is that
I
the
wouldn't
case?
say we're guessing. I'm saying we researched it and our best guess, because there isn't, it would be as if we never had auto insurance and then the state or the city council or somebody said, now you have to have auto insurance. It wouldn't be known at that time what it would be, but we'd have a rough idea of what it would be. And we believe it will be in the $300 to $400 range, because that's the typical policy cost. And I've checked around a number of cities around the country.
But you just don't know though, right?
Well, you couldn't know with certainty, and nobody ever could until the market opens. And frankly, it will be a variety of costs. We expect that various insurance companies will come in and they'll offer different kinds of insurance. As long as insurance meets the basic parameters, then officers are free to add other parts to the insurance, other riders and things like that, and could choose to purchase a more expensive plan. In fact, the FBI agents have choices of a few different plans that they can select that have more coverage and less coverage. They have a minimum that they have to select, but then they can choose things and pay a little bit more money for those. So it's the same thing that you run into when you purchase your homeowner's insurance, your car insurance. It's going to be a competitive market, and different insurance companies will offer different offerings. And as long as they meet the minimum threshold, then the cost will vary based on the company. So, but again, our best research shows that it would be between $300 and $400, probably closer to $400, like it was running around $370 to $380 was the average that I was getting when I did we did significant research on it.
May I add just briefly? The costs are, of course, an issue. And of course, the costs of the bad policing that we have right now are an issue that you face in the Ways and Means Committee quite frequently. But cost is not the issue before you today. The issue before you today is whether this amendment is legal. And the standard on this is that you start off with a ministerial duty that requires you to vote to put this on the ballot, with very narrow exceptions. Those exceptions have been opened up by the courts only for the purpose of avoiding the frustration and futility of an election that will immediately be overturned. As a result, the only exception to your being required to put this on the ballot is if you are certain beyond a reasonable doubt that this amendment is illegal.
Now, and illegal, by the way, would mean manifestly unconstitutional,
right,
is the language they typically use.
Or specifically violating a state law. At this time, Susan Siegel put out her opinion